Most buyers read the price, the deposit, flag the conditions, and then assume everything else in their real estate offer is just legal boilerplate. Well, it's not, and some of the most important protections you have as a buyer are buried in clauses that many people scroll right past. Now, I've reviewed hundreds of agreements of purchase and sale with clients, and representations and warranties are consistently one of the least understood parts of the contract. Now, if you're buying a home in Ontario, this video is going to show you exactly what your seller is legally promising you the moment they sign the agreement. And we're going to cover what you can do if those promises turn out to be false. My name is Soccio-Marandola. I'm a lawyer here in Toronto, and I help people like you close real estate deals every single day. Now, if you enjoy this type of content, make sure you subscribe and join our community. And if you have a closing coming up, we've built the most transparent legal fee calculator online. It gives you a full breakdown of every dollar you'll spend and even calculates closing costs like land transfer tax and title insurance. That's linked in the description down below. So let's start with the basics. What is a representation and warranty? In simple terms, it's a legal promise. The seller is making a statement about the property, and they're promising that that statement is true when they sign the agreement and when you close. These statements are essentially promissory conditions of the contract. If one turns out to be false, you as the buyer may have certain legal rights, such as the right to sue for damages. Now, the remedies available will always depend on the specific facts, but the point is, these clauses have legal teeth. You might be wondering, don't conditions already protect me? Now they do, but conditions typically deal with some sort of due diligence that you as a buyer undertake before the ultimate decision to proceed with the transaction. Now, once you fulfill your conditions and the deal goes firm, that protection is gone. Representations and warranties are the layer of protection that exists throughout the closing and in some instances beyond. So think of them this way. Conditions are your initial due diligence on the deal for a limited time. Representation and warranties are legal promises from the seller that protect you throughout the entire transaction. Now let's look at three of the most common ones you'll see in an agreement of purchase and sale. The first one we're going to look at is what's commonly referred to as a good working order clause. The seller represents and warrants that the chattels and fixtures, as included in this agreement of purchase and sale, will be in good working order and free from all liens and encumbrances on completion. The parties agree that this representation and warranty shall survive and not merge on completion of this transaction, but apply only to the state of the property at completion of this transaction. So the seller is representing and warranting that all the chattels and fixtures in the agreement, so your appliances, mechanicals, the items staying with the property, will be in good working order on closing day. Now, in practice, what does this mean? It means that if the dishwasher is not working or the fridge isn't running, you have a contractual right to claim back on the seller for damages. The way this clause is written, it creates a positive obligation on the seller. So even if one of those chattels were not in good working order when the agreement was signed, the clause states that the seller has agreed to ensure that it will be in good working order on the closing date. This is why it's recommended for clients to do one of their property visits right before closing. Not just to confirm the property is in the condition you expect, but to understand whether the chattels that were included in the deal are actually working. Now, ideally, you want to catch any of these issues before closing day in order to best preserve evidence to support your position in this. Now, the second clause I see often is the illegal substances representation and warranty. The seller represents and warrants that during the time the seller has owned the property, the use of the property and the buildings and structures thereon has not been for the growth or manufacture of any illegal substances, and that to the best of the seller's knowledge and belief, the use of the property and the buildings and structures thereon has never been for the growth or manufacture of illegal substances. This warranty shall survive and not merge on the completion of this transaction. So the seller is promising two things here. First, during the time they own the property, it has not been used for the growth and manufacture of illegal substances. That part is absolute. Second, to the best of their knowledge, the property has never been used that way. That part is qualified to their knowledge. Now that distinction matters, and it matters for a good reason, because a property used for that purpose can leave structural and contamination issues. Damaged framing, mold, electrical problems. It can affect your insurance and it can affect your financing. And it's not always something you can see on a showing. Now, there's an important nuance in the wording of the clause, right? The seller's obligation about their own period of ownership, of course, is absolute. But the warranty about what happened before they own the property is, of course, qualified to their knowledge because that's the best they can give. The third clause we're going to look at applies specifically to condo purchases. The seller represents and warrants that, with respect to the unit, the Condominium Act, declaration, bylaws, and rules of the condominium corporation have been complied with, and that no improvements, additions, alterations, or repairs that require the consent of the condominium corporation have been carried out in the said unit, the exclusive use areas, or the common elements unless the required consent has been obtained from the condominium corporation. This warranty shall survive and not merge on the completion of this transaction. So the seller's warranting that the Condominium Act, the declaration, the bylaws, and rules have all been complied with. And more specifically, that no improvements, additions, alterations, or repairs that require approval first were done so without that approval. Now, condo owners do things to their units all the time. They may remove walls, renovate bathrooms, update kitchens, and not everyone gets the proper approval from the condo corporation. Now, why is that your problem as the buyer? Because in a condo, unapproved work doesn't disappear when the property changes hands. The obligation to remedy it can follow the unit. You can be the one the condo corporation comes after to fix it, remove it, or restore the unit to its original state. This clause is your protection against inheriting someone else's compliance problem. It gives you a contractual right to claim against the seller if one of these issues is found later on. Now, two important things to note about representations and warranties. First, these three clauses that I just went through are not in an agreement of purchase and sale by default. That means that they need to be specifically added by the person drafting the agreement, which in most cases is going to be your realtor. Second, you'll notice that every single one of these examples contains the same language at the end. This warranty shall survive and not merge on the completion of this transaction. That line is doing something very specific. Now, in real estate law, there's a concept called merger. The idea is that once closing happens, the obligations in the agreement have all been met since the parties decided to close. So if a warranty merges on closing, you would lose your right to enforce it after that closing. We of course want to prevent that. If any of these promises turn out to be untrue after closing, we want to keep that contractual right intact in order to form a legal basis to act on them. So for clarity, and rather than leaving the point open to interpretation, these clauses make their intent explicit in the writing. The parties are agreeing up front that the warranty survives and does not merge on closing. Remember though, it doesn't mean that the seller is warranting the condition of the appliances after the closing, but if that appliance was not in working order prior to closing, and you found that information out after the fact, then with the proper evidence, you can still rely on that clause in the contract. So those are three of the more common representations and warranties you'll find in an Ontario agreement of purchase and sale. They're not filler, they're real legal promises. If you're going into a closing or into a transaction right now, make sure you understand what exactly is in your agreement and what promises the seller is making to you. If you're enjoying these behind the scenes real estate law videos, make sure you subscribe to the channel. I post a new video every week. And if you're a realtor, I also send a weekly update about different legal situations that come up in our closings. That's our realtor newsletter, and you can subscribe to it with the link down in the description. Thanks for watching.